Alright, this is Deuce We the People News, one more time at it. Alright, you know how this goes. I'm not an attorney, people. I do not give legal advice. Why? Because I don't have a bar license, and therefore, somehow or another, I signed a contract saying I'm not an attorney. Nor am I your actual counsel. Anything I say or do is just my opinion. It's hearsay. Alright, do your own research. Never look straight forward, always look around to be able to protect yourself by any means necessary. Use that Second Amendment. Arm yourself with knowledge. And even though this is all, these videos benefit me, since it's in public, make yourself at home. Grow, grow, grow. Realize we're the people and we're not subjects. Realize that the legal person is subjects. Okay? So, this one I kind of liked. Well, there's no kind of. But we need clarification. Bill of attainer is very important, right? Because a lot of things government's doing has been putting us in bill of attainers and all that. Well, we needed to get some clarification. So, let's go.
Particular in this case.
Oh, by the way, you may hear the background. People are up and moving around still.
A bill of attainder means any legislative act, no matter what their form, that applies either to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, also termed act of attainder.
Also in Texas, it's Article 16. All right, Bill of Attainder. It's been such a long time to look that up. I know it's 16. I don't know if it's Article 1, Section 16. I cannot remember. But it's in the Texas Constitution as well as everybody else's state. Now, this is blurry. But I wanted to get you guys to have clarification. Write it down. All right, for some of y'all on phones, we're going to read it. Do-do-do-do-do. It's not going to be perfect, y'all. Why? Because I'm not God. I cannot be perfect. So, anyway. I just wanted to kind of do this short video and recognize what he just said at the beginning. So, rewind it back. Listen to what he said at the beginning. It's a legislature act. Administrative is legislative, right? Article 3 is just judicial. We don't see judges. We see magistrates. We are in administrative courts. All right? Administrative still could be under the UCC. It could be under the MLT, which is really military. Merchant, the sea. All right? But they use all these things against us and turn around and say, hey, oh shit, you guys are sovereign citizens. Even though you guys can't cause us harm. All right.
And then it goes on, bills of pains and penalties. A bill of pains and penalties, a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bills of pains and penalties are included in the U.S. Constitution ban on bills of attainder. Our U.S. Constitution, Article 1, Section 9, and that's Black's Law Dictionary, 8th edition, page 499.
Now, you did bring up Black's Law, and I like Black's Law. However, when you go with the founding fathers when they written everything, right? You actually have to use the definition of that day, that period, to find out the true intent. Because over time, words and definitions has in fact changed. And, Webster, don't look up Webster when you want to find out the original intent of the federal constitution, or even some of your states, right? Some of our states, was in the Black Law era, but the most important thing is use the definition of dictionaries of that time of the federal constitution, right? So we could get a clearly uneducated reading of the intent of the Constitution. This is the reason why they keep on saying, well, the Constitution's living. No, you're just changing words, you're changing definitions to fit your narrative, right? So we got to divert back into the original intent.
Preamble posterity. The demandant failed to give this court any authority over the demandant, and this so-called court has no authority to make any legal determinations for the demandant or represent the demandant in any way. Will Livingston, that ratified the Constitution for New Jersey, 18 December 1787, is the demandant's fourth-grade uncle, and the demandant is posterity as found in the preamble. We, the people of the United States, in order to perform a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and all the laws of Texas are civil laws. And the right of blood and kindred cannot be destroyed by any civil law. And that's Bouvier's Law Dictionary, 1856 edition. And this court, as well as all of the wrongdoers, are operating under a power which is derived from the demandant as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. That's another maxim of law, Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the demandant to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And John Marshall, the Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed and said it was impossible for the demandant, as one of we the people, to confer a sovereignty which will extend over him. This is McCullough versus Maryland, U.S. Supreme Court. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And that's McCullough versus Maryland. And the demandant is exempt from these wrongdoers and from all the claims of their bar members, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power.
All right, so I went a little further to just kind of give a little time on this video, mainly so it doesn't turn into a short. However, the main point is to read the Bill of Attainder and how they've been tricking us. Okay, so this weeds the Diesel for We the People News. Okay? People, educate yourself. Be the people. Okay? Be the people. And just like previous, be the state. Okay? And if you have to, since you are the state, claim the 11th Amendment. That'll screw them up. All right. Till next time. Bye, y'all.